Item number 15.
May it please, Your Lordship.
Yes.
Book offence. This is the order.
1 to 15.
Yes, my lord. This is relating to work charge establishment, but counsel for the respondent is in bereavement, my lord.
Can you have this matter on Thursday?
You were appearing for the
Yes, my lord. I am appearing in item number 1. However, in item number, the counsel for item number 2 to item number 15 is in bereavement. So somebody passed away in his family and today is the funeral. So it requested me to make a mention. My lords, if you can have it on Thursday.
Thursday, those bonded warehouse matters are listed, my lord. Thursday, Friday.
Give a date.
Hmm? 27. 27, you have difficulty. What do you do first?
Learned counsel for the respondent in one appeal.
No, my
Appeal
lord.
number-
From item number 2 to item number 15.
In all the appeals except one has suffered bereavement and is unable to come to court. Full stop. Adjournment is prayed for on his behalf. Learned Advocate General for the appearing for the appellant takes a sympathetic view of the matter. Next, by consent of learned, by consent of appearing counsel for the parties, this batch of appeals is adjourned till 27th.
Which day?
Grateful, my lord.
27th
27th.
August 2025.
Oh, great.
Item number 16.
27th or 27th?
Yes.
This is a matter regarding appointment of judicial officers.
Yes.
This matter pertains to Millard's appointment of judicial officers, magistrate first class in the district council courts, where my lords had heard me at some length. Now, the principal challenge, my lords, is on 2 counts.
5 posts were vacant, 3 were advertised, filled up.
My lord. One post was sanctioned
Subsequently, my lords,
immediately, my lord, soon thereafter.
So, Mr. Paul's contention is that if it is all the posts are filled up, so the panel also becomes exhausted.
My
my
lord.
lords. And the law, my lords, as it stands is, my lords, in normal circumstances, the moment the life of a select list is, my lords, 1 year, and otherwise also expires the moment the appointments are made on the basis of that select list. But the Honorable Supreme Court also says, my lords, in exceptional circumstances and under emergent requirements, after taking a policy decision in this regard, my lords, the select list can be extended and appointments can be made. Now, the justification given, my lords, that's where we'll have to come to the justification given by the district council. Now, I'll first draw your lordship's attention to the order by which the select list was extended. My lords would find that at page 75 of the paper book.
Mr. Paul, you sit down for some time and regain your breath.
My lords, I'm grateful, my
Yes,
lords.
we will go. I will go through my notes
My lords.
in the meantime.
I'm grateful, my lords.
Page 71 and page 160 others.
My lords. My lords, I just wanted to point out, I'll take your lordships to the, my lords, the extension that my lords would find at page 75. My lords, 76 is the typed copy. My lords, it reads, in continuation, if my lords have it. Page 76.
And page 170,
170 minutes.
no, first is page 160. That very day, the new post was created,
My lords.
160. Please come to page 71 first.
My lords. 19th August 2021 is the date. Letters
He's
written to
saying
the
that we'll fill it up from the waitlisted
Well.
candidates list.
Lordships. And that post is created, as your lordships have rightly pointed
Same
out,
day.
on the same day at page 160.
So 5 becomes 6.
6.
Page 76, validity of the notification means validity of the panel.
My lords. At page 70, my lords, last line, if your lordships kindly see, the result is valid for a period of 1 year from the date of this notification.
Page 71.
Page 70, my lords. Last line. This is the select list, my lords. It says the result is valid for a period of 1 year from the date of this notification. Now, at page 76, my lords, is the notification by which the validity is actually extended. That, my lords, would find at 6 December 2021, date at page 76. Now, this notification, my lords, does not specify any of the requirements as is mandated by law. Because it simply says, my lords, in continuation of this office order number so-and-so, dated the 11th to... I think that there is a typo error again, my lords. 11/1/2021 it should be. The Executive Committee, Khasi Hills Autonomous District Council, is pleased to extend the validity of the said notification up to 31st March 2022. Now, what I was pointing out, my lords, and I place the law requires, my lords, it says that very well, under exceptional circumstances and in emergent situations, the select list can be extended, but there must be a policy decision to that effect. What I pointed out at page 76 is, my lords, that there is no policy decision to the extent that because of this emergent situation and this exceptional circumstances, a decision is taken to extend. It simply says, my lords, is extended. So there is no my lords, application by the executive committee to the fact that under what circumstances you are actually extending this. Now, it can very well be argued, my lords, and I must point out before your lordships, I must draw your lordships' attention to page 71. Now, this is the letter, my lords, which is written by the district council to this honorable court, my lords, seeking approval for extension. If my lords kindly have page 71, my lords. It says, my lords, this is a letter dated the 9th of August 2021, which says, in inviting reference to your letter number so-and-so, the executive committee has appointed so-and-so, so-and-so, so-and-so as magistrate first class subordinate district council's court who have also joined the said posts. However, it may be informed that there are few more vacant posts of magistrates first class as per the current budget provision, and in view of the current situation in the state and country as a whole, it may not be conducive to conduct fresh examinations for the filling up of the said vacant posts. The executive committee has, for strengthening and functioning of the district council courts, recommended to fill up the remaining vacant posts from the candidates in the waiting list. Moreover, there are many pending cases which require speedy trial, and the executive committee is also contemplating to make the district council court function in all district headquarters via Nongstoin, West Khasi Hills, Ribhoy, etc., etc. Therefore, it is once again requested to fill up the remaining vacant posts be the candidates in the waiting list as per notification may, as a special consideration, may be approved for appointment as magistrates. My lords, I have two submissions to make here. As my lords have rightly noticed, on the date of making of the advertisement, my lords, which is on 6/11/2019, there existed 5 vacant posts. That's an admitted position. That all these 5 posts were vacant. And my lords, that is borne out by their counter affidavit. I'll just point out the page. Give me the page. No, it's flagged. Not this. What did this show me? Para 10. Para 10 of the counter affidavit. Well, I'll just take your lordships.
Para
127.
Affidavit para 8.
Will not be here. In my memo of appeal, my lords, it's at page 127. Paper book.
Additional.
38. No. Well, it's if my lords kindly come to page 143 of the paper book, paragraph 8 of the additional affidavit that was filed by the district council. Now, it is stated here, my lords, that on 6th November 2019, a total of 5 vacant posts of magistrates were available to be filled up, but the advertisement was issued for only 3 posts. So it is not a case, my lords, that there was an anticipation that these posts would be filled up or not. They deliberately chose at that point of time in 2019, well before the pandemic, not to advertise 2 posts. And they say, my lords, the idea was that 1 more post will be sanctioned very soon, and thereafter the recruitment process for filling up of the 3 posts would be initiated. There is no justification for that, my lords, assuming, my lords, only for the sake of argument. If 1 post is subsequently, my lords, approved or sanctioned, there was nothing barring them from, my lords, making an advertisement for that 1 post. So, having chosen, my lords, not to make an advertisement in respect of 2 vacant posts in 2019, in 2021, therefore, my lords, my first submission would be, you cannot say that it was an exceptional circumstance or an emergent situation under which those posts had to be filled up from the existing criteria, my lords, existing pool of three selected candidates who were waiting. So, my lords, the first test of emergency fails. The second test is, my lords, that of exceptional circumstance. Now, the justification given by the district council is, my lords, at that given point of time, it was COVID. Now, we, my lords, have taken the liberty to go through the national database of the Government of India. And, my lords, from the period, show me that breakup. Right from when that first letter is written to the Honorable High Court, my lords, in the month of August, there was no COVID in the country. There were exceptional cases of COVID here and there, my lords, but it was not a pandemic, and there was no official notification of the Government of India for the purposes of it being within the pandemic period. My lords, the dates are available, my lords, and as your lordships are aware, the first phase of lockdown, my lords, was from the 25th of March 2020 till the 14th of April 2020. The second phase was from 15th of April 2020 till the 3rd of May 2020. Phase 3 was 4th of May 2020 till 17th May 2020. Fourth phase was 18th May 2020 until 31st May 2020. Thereafter, my lords, at various times, there were these small intervals when, my lords, there was indeed a lockdown. But post-August 2021, there was no COVID per se, my lords, for the purposes of not holding any selection. So that itself also will not hold good. The third criteria, my lords, which, as your lordships have laid down in the law, is that there has to be a policy decision. It has to be a policy. The government has to come with a policy saying that no, for meeting this particular emergent and my lords, exceptional criteria, this decision is taken and therefore it is to be implemented. Here what we see, my lords, from facts is that a letter is written the day the post is sanctioned at page 160, as my lords have pointed out. At 71, my lords, a letter is shot to the High Court. And, my lords, on the basis of an approval which is given by the High Court, which I say, my lords, with all due respect, was not even required. Because that policy, if at all, had to be taken by the District Council. High Court could not have guided them on this.
So how many candidates applied?
For the selection process, my lords,
Yes.
well, it's that my learned friend will be in a position to say they do not disclose it in the...
My lord, total 100 candidates applied. Out of 100, 17 were found to be ineligible. 87 were found eligible, but only 62 appeared in the written, out of which 6 passed, 6 secured the minimum qualifying marks prescribed. Rest, including the appellant, did not even secure the minimum qualifying marks, and they did not qualify in the written.
My lords, that, my lords, is again something that I will have to deal with. Because one of the positions that have been taken, or one of the challenges to my locus.
Once more, please tell us how many candidates were there? 100.
100, my lord. 100 candidates applied. Out of which a list of eligible applicants were published on 23rd of October 2020. There are 87. 87. And out of 87, my lord, 13 were found to be ineligible out of 100.
Out of 87, again 13.
No, out of 87, out of 100, 87 were found eligible.
Yes.
for examination, my lord. And 13 where their applications were rejected. Out of 87, only 62 took the exam. That I have filed in an affidavit before your lordship on 5th of May 2025.
Is that 5th of May 2025?
Yes, I have filed an affidavit, my lord.
Yes.
My lord, that affidavit will show, if your lordship can have that affidavit. My lord, junior.
No, you just give us the figures.
My lord, the
62.
62 candidates appeared, including the appellant, for written examination. For written examination.
And 6 qualified.
And 6 qualified.
At the qualified marks.
Yes, my lord. They got minimum qualifying marks. My lord can see page 70. 6 appeared for the viva voce, and then the select list your lordship will get at page 69, but it is not very clear. 70 is the typed copy.
Yes.
So that is the position, my lord.
Yes, Mr. Paul.
My lords. So what I'm submitting before your lordships is that A, my lords, there is no policy decision. B, there was no emergency. And C,
Yes.
my lords, that there was no exceptional circumstances factually. On facts, my lords, it cannot be sustained. The learned single judge, my lords, comes to 3 findings. And I'll take your lordships to that, my lords, of the paper book, if my lords kindly have page 299. At paragraph 22. If before that, my lords, if I may first take your lordships to page 291. These are the findings of the learned single judge at page 16. Paragraph 16, page 291.
Yes.
My lords, it says, as noted from the discussions made herein above, the reasons given by the respondent number 1 for appointments is threefold. First is that the holding of fresh examinations for 3 posts was not feasible and conducive due to the COVID pandemic in 2021. Well, I've submitted before your lordships that as per the national database, there was no COVID in 2021. The restrictions imposed by the state all expired in the year 2020, which was at its peak. It's an absolute perverse finding. Secondly, due to the demand, benches of the district council were to be commissioned in 3 outlying districts, namely West Khasi, South Khasi, Ribhoi. And thirdly, due to the need of speedy trial of cases, to this end, as submitted, a considered policy decision has been taken by the respondent number 1 under what has been termed as exceptional circumstances and emergent situations. My lords, this finding at paragraph 16, your lordships will see from where is it coming. Because the impugned order, my lords, does not say that there is any policy decision. It does not say that because of these reasons, my lords, this policy decision is being taken. But the learned single judge, my lords, imports something from some correspondence that was made and says that that is a policy decision. My humble submission is, my lords, there is no decision. There is no policy decision to the extent of making these appointments. Now, at paragraph 22, my lords, are the findings of the learned single judge at page 299. The first finding is, my lords, form an examination of the above noted decisions, and I'll take my lords through the law.
No, but when were they appointed?
Well, it's the appointment orders were issued in 22. Two appointment orders were issued on 28/2/2022. And my lords, one appointment order was issued on 4/3/2022. That my lords would find at page 81, 82 to 90 of the paper book. Respondent, tell me. I'll give the specifics, my lords. Well, it's in respect of respondent number 4. It is issued on the 28th of February 2022 at page 83.
Respondent 5.
Respondent number 5, my lords, it is again issued on the same date on 28th February 2022.
20.
28, my lords. 28th. And in respect of respondent number 6, my lords, the order is issued on 4th of March 2022.
28th February respondent numbers
4 and 5, my lords.
and 4th March,
Respondent number 6,
4th March 2022.
2022. And all of them joined, my lords, on 8/3/2022. That my lords would find from page 91 onwards.
And the other two?
All of them joined on the same day, my lords, 8th of March 2022.
No, 3 were appointed.
These are the residual 3, my lords, whose appointment is under challenge. The original 3 were appointed, my lords. I'll just give the date, my lords. 69. Original 3.
So 19th August 2021.
138.
You can give that later. This is not very material at all.
My lords. So I was taking, my lords, to the findings of the learned single judge, my lords, at paragraph 22. At page 299.
Yes.
May I read?
You placed it on the last occasion also.
My lords, from an examination of the above noted decisions, what emerges is such deviations are permissible when exceptional circumstances are prevalent, or the same is resorted to meet an emergent situation. Further, it is also clear that such appointments would be permissible for clear vacancies and anticipated vacancies, but not for future vacancies. In the case at hand, by applying the above conditions and contingencies, it can be safely be held that the deviation from the advertisement was caused by events narrated earlier, for which a considered policy decision was taken to address the situation. As such, the same calls for no interference. On the aspect of vacancies for which appointments were made from the waiting, the same way as against 2 existing vacancies, and 1 was against an anticipated vacancy, which was under the process of being sanctioned and was therefore sanctioned by letter dated so and so. As such, the appointments were not made against future vacancies. So my submission to this was, my lords, at least the appointment of respondent number 6, my lords, which is against the 6th post, is definitely against a future vacancy, because on the date of the advertisement, that post did not exist itself. So I can anticipate, my lords, in respect of a post which is there, something which is non-existent, my lords, would definitely be a future vacancy. It cannot be an anticipated vacancy. That was my first submission. Second, my lords, I have said in terms of the law, there was no policy decision, no emergent situation, no urgency, my lords, otherwise. Well, I'll just place the law before your lordships, my lords.
Accepted. That the law is accepted.
My lords.
You can give the citation.
My lords. I'll just place two decisions, my lords, and I would have to
No,
deal
you
with...
just you cite and give the proposition, and if you want to cite it, you cite it. There's no harm.
Well, it's just two, because the rest is a reiteration, my lords. I'll first place Prem Singh. Well, the first decision is 1996 4 SSC, page 319. Tell them that the book has not come. Page. This is annexed to my memo of appeal, my lords. I'll just place it. My lords would find it at page 173 of the paper book before my lords. The relevant paragraph will be at para 25.
Page.
Well, it starts from page 173. That my lords would find at page 191 of the paper book. Paragraph 25, my lords, if I may just please. From the above discussions of the case law, it becomes clear that the selection process by way of requisition and advertisement can be started for clear vacancies and also for anticipated vacancies, but not for future vacancies. If the requisition and advertisement are for a certain number of posts, only the state cannot make more appointments than the number of posts advertised, even though it might have prepared a select list of more candidates. The state can deviate from the advertisement and make appointments on posts falling vacant thereafter in exceptional circumstances only, or in an emergent situation, and that too by taking a policy decision in this behalf. Even while filling up of posts, even when filling up of more posts than advertised is challenged, the court may not, while exercising its extraordinary jurisdiction, invalidate the excess appointments and may mold the relief in such a manner as to strike a balance between the interest of the state and the interest of the person seeking public employment. What relief should be granted in case would depend upon the facts and circumstances of each case. Well, I must concede that this is how the law emanates. That my lords may not strike it down, but my lords will then decide how the relief is to be molded. Now, a challenge was made, my lords, before the learned single judge and of course also before this honorable court, with regard to the locus of the petitioner, my lords. In the sense, what is argued before this honorable court is that I have not cleared the written examination. I did not get the basic marks. So, my lords, a challenge by me could not be maintained through the appointments made. That is also answered in this very judgment itself, my lords, at paragraph 12. As I'll very quickly read 11 and then point out para 12, my lords. The preposition is at para 12. The challenge was at para 11. At page 182 of this paper book, my lords would have it. It was next contended by the learned counsel for the appellants that the selection of the candidates in excess of the number of posts advertised does not per se offend the equality guaranteed under Articles 14 and 16 of the Constitution. It was submitted that in view of the delay which was likely to take place in the process of selection of appointments, it was permissible for the board to take into consideration anticipated vacancies and to make provisions for the same. They have further submitted that the High Court should not have quashed the selection and set aside the appointments at the instance of the original writ petitioners, as in any case they were not selected by the selection committee, and therefore were not likely to get any benefit by getting the selection of the appointments invalidated. Well, essentially, this is the challenge as against me. The learned counsels also questioned the locus of the writ petitioners, as all of them except one had taken part in the process of selection without any objection. They also pointed out so-and-so, so-and-so ballots. The preposition is at para 12. In our opinion, there is no substance in the objection raised with respect to the locus of the original writ petitioners. The candidates could not have anticipated when they appeared for the interview that the selection committee would recommend candidates and the board would make appointments far in excess of the advertised posts. The petitioner who was not eligible had just, well, it's not relevant for our purposes. My only answer to this entire challenge would be there, Malaj, simply because when 3 posts were advertised and I applied and I could not, Malaj, succeed, would not necessarily mean that if the 3 posts were subsequently again advertised and I had participated, because it's not a case that I was not eligible. I did not have the essential criteria. I had the criteria, I participated, I could not pass. So merely because I did not pass the first examination, Malaj, would not stand against me that I would not be able to clear the second examination if at all it had been advertised.
You had a chance to participate.
My lords, I have been deprived of a chance, my lords. That is the case of the writ petitioners before the writ court, that they have been deprived of a chance. Had the post been advertised, then, my lords, they would have participated and they stood a fair chance. Because otherwise also, my lords, as your lordships are aware, the corollary to this was essentially that merely because somebody's name figures on a select list, that would not confer any rights on them insofar as, well, as getting appointed is concerned.
All right. Any other decision, Mr.
Well, it's just one more. This is with regard to, my lords, the validity of the select list. And it essentially reiterates the same thing, my lords. This is, my lords, 2007 8 SCC, page 161. Have the books come? There are 9. The relevant paragraph is paragraph 9, my lords. This, my lords, is only with this second part where it says, my lords, at page 165, if I may read from the second line, my lords, vacancies which arose in the subsequent years could not be filled up from the select list prepared in the previous year and not in any other manner. Even otherwise, in the absence of any rule, ordinarily, period of validity of select list should be 1 year. My lords, and then 2 judgments are referred to. And, well, it's this same preposition is again reiterated in, my lords, 2006 12 SCC 561, saying that it is, my lords, this is the second decision, State of Bihar versus Amrendra Kumar Mishra, where they say that it is ordinarily 1 year.
Which is the next decision?
The second one is, my lords, 2006 12 SCC, page 561.
581.
561, my lords.
They say in the absence of any stipulation?
It should be 1 year. The relevant paragraph is again paragraph 9. It says, my lords, if a very small paragraph, it says, in the aforementioned situation, in our opinion, he did not have any legal right to be appointed. Life of a panel, it is well known, remains valid for 1 year. Once it lapses, unless an appropriate order is issued by the state, no appointment can be made out of the said panel. And that's when, my lords, Prem Singh comes in, because Prem Singh says that you can extend it, but under these circumstances.
Please go to
And one more finding is there of the learned single judge, my lords, which I had said in some way where Prem Singh comes in. They say, my lords, that these officers have otherwise also been serving for some period of time. So whether at this stage my lords would interfere with that appointment, that my lords, once they argue, then I can in my rejoinder I can deal with that.
Yes.
I'll oblige.
On the last occasion, you said that one or two had not joined.
No, my lord, what I submitted, my lord, one post is vacant now, right now, my lord, and one vacancy is arising on the end of this month, my lord, on 31st of August. One incumbent is superannuating, my lord. So we are in a position to advertise two posts now, my lord, immediately. And my concession was, my lord, if the writ petitioner is over age, my lord, we can, your lordship directs us, we will condone that, my lord. And he gets a fair chance of participating in the process once again, my lord. Because that can be the only grievance he has, my lord. Apart from that, because your lordship, I'll place that he scored 57 marks, my lord. The cutoff was 120. He scored only 57, my lord. He was not in the, he could not qualify the written test, my lord.
No, only one of the candidates has preferred this writ.
Only one of them.
Others have not.
Writ was by two, my lord. And after,
Both dismissed.
Writ petition was dismissed, my lord. Now the appeal, in the appeal, there is only one petitioner is there. Only one appellant is come.
And there is no other litigant
No other
in that selection.
No, my lord. But in fact, I'll place two decisions, very recent 2024 decisions of Supreme Court, my lord. C.T. Ravi Kumar and, sorry, where in more or less identical circumstances, my lord, the Honorable Supreme Court said there is no allegation that there was any kind of malafide or wrongdoing in the selection process, or the appointees contributed to, or in the selection process, my lord. The selection process was completely fair, my lord. The only issue was there was appointment from the waiting list, my lord. The Supreme Court said, my lord, the equity is in favor of their continuance because for 3.5 years they are continuing to serve, my lord. And
6 years.
only on that ground, if I may just place those two decisions, my lord. But the other aspect, which before I place the judgment, my lord, COVID aspect, my lord. The COVID aspect, even the Honorable Supreme Court has extended till 28th of February 22, my lord. Now to say that only lockdown is COVID exigency, my lord, and the other period till February 22 is not a COVID period, there is no exigency, my lord. Lordship will examine that aspect, my lord. The period my friend has pointed out was complete lockdown, my lord. The Honorable Supreme Court in suo motu matter, my lord, had extended the COVID.
No, what is this?
But I'm just,
24?
the first decision is 24-3 SCC 799, my lord.
How much time you are likely to take?
I'll
I
just
think
read
10 or 15 minutes.
my lord.
We will continue tomorrow. That's all right, Mr. Paul? And who else will make submissions?
Mr. Mishra is
Mr. Mishra,
for the private respondents.
We will continue tomorrow, Mr. Mishra.
My lord.
State will adopt the submission of redress counsel, your lord.
You see, the equity, for whatever reason, they are there for 3 years now.
3.5 years, my lord.
Yes. Judicial magistrates recruited with the approval of the High Court. Now one is vacant. One is to fall vacant.
My lord.
Create one more. There is no harm if one supernumerary post is created,
My lord.
and throw it open to competition.
My lordship, give one line observation or direction, my lord, we'll do it, my lord.
That should not come from this honorable court, my lords. My lords had indicated this quite some time
Because
back.
you have said that more judicial officers are needed.
There are, because what happened, my lord, earlier district council court was for the entire 6 districts, I think, was in Shillong only, my lord. Now we have created outlying benches because the Khasiel district is quite huge, my lord, running into maybe the length and breadth 200 kilometers, my lord. So the rural population had to travel to Shillong, my lord, and especially during the COVID period, it became very difficult for them, my lord. And that was the reason we created 3 outlying benches of district council courts, my lord, one in Nongpo, one in Nongstow.
Because the cause of action or grievances with regard to the 3 additional recruitments.
My lord.
My lords.
The first
Original
three,
three, my lords, there's no dispute.
they are not challenging. So as far as 3 is concerned, whatever may be, since vacancy is there, create one supernumerary because you always need more magistrates and judges,
My lord.
and throw it open to a selection process.
Well, I'll urge your lordship to kindly one line direction will
No,
immediately. do that,
you make your submissions. We have to record your submissions and then come to that.
my lord.
That's
But it would work the other way. It would be injustice to throw out people who are there for 3 years. What wrong they have done?
And that's what the Honorable Supreme Court in these decisions has exactly the same view has been taken, my lord. That it will be too harsh on them because there is no wrongdoing on their part.
We will
continue
hear,
tomorrow.
yes,
we'll continue.
Mr. Learned Senior Advocate for such and such concludes his argument. Dr. Mozika, Learned Deputy Solicitor General,
For District Council.
commences his argument but does not conclude the same list. This one appeal or more than one appeal?
One appeal, my lords.
For further hearing tomorrow.
I'll be back.
All right.
Item number 7 and 18.
My lord, 17 and 18 are connected matters, my lord. Item number 17 and 18 are connected. In 17, my lord, they appeared earlier, my lord, but item number 18, there was no representation. Even after the notices were served, my lord.
Lordship, if I may submit.
Yes.
Lordship, in item 18 now we have received telephonic instructions from the respondents to appear for them in this matter as well, Lordship. We'll be filing a vakaranma in short time, Lordship. Kindly grant us 10 days time to file the vakaranma
Give us the
report.
order sheets.
Item 18.
So the 18th, sir, Lordship.
The paper book in 8 is good for 9 also.
Yes, my lord. It's identical matters.
Lordship, identical matters. Lordship, in item 18, Your Lordship, I have telephonic instructions to appear for the respondents.
Whatever instructions you have, the paper book can be used or not.
Lordship, we'll collect it from them, Your Lordship.
All right.
Kindly grant us 10 days time to.
So this appeal, both the appeals become ready for hearing.
Yes, Your Lordship.
All right. Please take down. Mr. M. Chanda, learned advocate.
Lordship, it's Vice M. Chanda. Lordship.
Yes.
I'm
What
ML
is
Nompure,
your
Lordship.
name?
ML Nompure, Lordship.
Huh?
ML Nompure, Vice M. Chanda, Lordship.
Who's Mr. Chanda?
He's from Guwahati, Lordship. He's the outgoing counsel.
All right. Mr. M.L. Nongpure, learned advocate, now has instructions to act on behalf of the respondents in the appeal WA 9 of 2025. Full stop. Full stop. He confirms that the paper book in the connected appeal WA8 of 2025 could be used as papers in the appeal WA9 of 2025. Mr. Nongipur is given leave to file the Wakalatnama on behalf of the said respondents. Both the appeals are now ready for hearing. When?
After 10 days.
List the appeals on 28th August 28.
I'll oblige.
Over? 2 more hours, please. Yes.
Item number 19.
Well, sir,
Ready for hearing?
I'm sorry, Milord.
Ready for hearing?
Milord, this is a matter which my lords have already heard. I am a fresh entrant in this matter. Mr. Mazumdar was earlier, Milords, appearing.
Yes.
He's since, Milords, been
Elevated.
elevated.
You are freshly engaged.
I am freshly engaged, Milords. But this issue, Milords, I would humbly submit, is covered by an order passed by my lords on 5/11/2024, where there was some amount of consensus between both the parties. Insofar as a certain, Milords, scheme was to be notified, and my lords had directed that the state do it. Now, that has not been done, Milords, and...
There are certain steps, my lord, which we have
No,
taken.
the appeal is ready for hearing.
Yes, my lord, appeal is ready for hearing.
ready for hearing.
So we'll keep it sometime in September.
Yes, my lord.
Well, may I pray if my lords have it next week, because I would say that this appeal
Next week
need not go in for hearing, my lord, because my lords have already dealt with the matter and passed an order on 5/11.
After that also some orders have been passed.
All right. By consent of learned counsel for the parties, list this appeal for hearing on 28th August.
That is obliged.
Number 20.
Criminal appeal. This is a criminal appeal, my lords. It takes some time if my lords so.
Ready for hearing.
Otherwise, ready for hearing.
Ready for hearing. I'm instructed to
Same
say.
by consent of learned counsel for the parties. Yes. Let it appear on 26th, then we'll see.
My lords. I'll oblige.
Single bench will sit immediately.
Item number 1.
Yes, who's appearing in item number 1?
Well, I'm appearing for the appellant, my lord.
I'm
This is a matter Lordship heard on last Monday, my lord. Here, land was acquired, my lord, for the central government purposes. Initially, the collector determined the land compensation at the rate of 160 rupees per square feet, my lord, and that was based on the circle rate fixed by the every district, my lord. Now, the respondent collected the award under protest, my lord, and filed an section 18 reference before the learned court below, my lord. And learned court below has enhanced the compensation from 160 to 300 rupees, my lord.
On the basis of a sale agreement.
But the two documents basically were relied on, my lord. The first document, if I may take your lordship, is a sale.
Exhibit 17.
Is page 30. It is a sale agreement on or around same time, my lord, which was for sale of a plot of land, a very small size of plot of land, my lord, at the rate of 300 rupees. That is, your lordship will find is page 37, my lord.
37.
Yes, you showed me page 131. Valuation is 12/8/2003, 200.
My lord.
And 4/7, the very next page, 131, 132.
My lord.
Post July 24, perhaps.
But in fact, there were three documents relied on by the trial court, my lord. Another document is at page 55, my lord.
It's very difficult.
My lord, kindly turn to page 55, my lord. This was the land acquisition award, my lord, in respect of a different plot of land belonging to the same respondent, my lord. This land was acquired for a different ministry, my lord, Ministry of Environment and Forest.
Page 55.
Yes, my lord. Page 54 is the notification, my lord. The previous page, lordship will see, this is the notification dated 6 December 2005, my lord.
Yes.
And the award is page 55, my lord. And that was at the rate of 200 rupees per square feet. Your lordship kindly see, my lord. 2.5 acres or 108,900 square feet at the rate of rupees 200.
And what is the date of this award?
This award is dated
6/12/2005.
No, that is the other one. Page 54.
Well, this award is 29/9/2008, my lord.
8. Where is it? It is not there. No, this was 2005 only. stamp duty.
Yes.
There is no date, my lord. I cannot find date. Annexure 13 and 14, page 55 and 56. Just signed, Form 5 is filed.
No, you will find the date at page 54. 6
That is, my
December.
lord, that's what I said, my lord. 6 December 2005.
Right.
And 2005, this was acquired.
And your land, Mr. Mishra?
My lord, this is part of this is our land.
But in fact, both belong to the respondent, my lord.
No, this was 200.
But the earlier acquisition was for Ministry of Environment, my lord, and the present acquisition is for Ministry of Foreign Affairs, my lord.
This was in 2005.
So same plot of land, one part was acquired in 2005, my lord, and the one part was acquired in 2007, which is the subject.
2005 was 200.
My lord, that was determined at the rate of 200 rupees, my lord.
That is circle rate, my lord.
And the other part when it was acquired?
2007.
Present acquisition is of 2007, my lord. The first notification was issued on 19/9/2007, my lord. The second acquisition.
The second is 300.
300, my lord.
Second, collector awarded 160, my lord. The court has enhanced it to 300 rupees.
So if on the basis of a 29th August 2006 transaction, it has been raised from 200 to 300, what is the informative?
But our case is, my lord, this transaction is only in respect of a small plot of land, my lord, of 4,000 square feet.
This one,
The sale transaction which they have cited, my lord,
which is 300.
4,000 square feet, my lord.
No.
Yes,
What is small,
rate was 300 rupees, my lord.
of a small plot of land?
Small plot of land, my
So
lord.
how will the size of the land change the rate?
But there are some judgments, my lord. In some cases, size of the plot will matter, my lord. Because large plot of land will not fetch the same price as small plot of land.
So what is the difference caused between 200 and 300 in the aggregate sale value? Mr. Mishra, what is the difference?
The acquisition here is about 3.5 acres of land, my lord.
No, how much more he is getting by virtue of the district judge's order?
By virtue of district judge.
And earlier, my lord, it was 3 crores 37 lakhs. Now the calculation has to be done. I will get at the rate of 300 per square feet.
That we have understood.
And, my lord. Now, my lord, your lordship has seen that Mr. Mojika
So how
has
much you
just,
will get at the rate of 300?
my lord,
how
that
much-
has not been calculated.
About 2.5
as
crore
yet.
rupees, my lord.
Huh?
He'll get additional 2.5 crore rupees, roughly, my lord.
All right. You filed your notes. I am making it CAB. You filed your written notes. I am making
My
it
lord,
CAB.
I have some submissions to make.
What
Lordship may take it tomorrow or any day, but I have some submissions to make.
what submissions you will make?
My lord, first of all, the collector fixes the valuation of the land for the purpose of stamp duty, not market value. So it cannot be treated as valuation under section 23 of the Land Acquisition Act. And if your lordship will kindly see paragraph 14 of their written statement, because there is no evidence, at page 59, if my lord will kindly see page 59. It will take some time, my lord, at least. So your lordship may take it up any other day, but my lord will kindly come to relevant is page 61. Their written statement of the collector, defendant number 1.
What are the points you want to? What are the points you want to take?
First, the point that I want to place before your lordship is that valuation of land is to be decided on the basis of market rate, not on the valuation rate fixed by the deputy commissioner, because that is only for the purpose of stamp duty, my lord. And I have 2 decisions. Many decisions, I'll place 2 decisions on the point of the Supreme Court decisions, my lord.
Market rate, not circle rate.
Not circle rate.
Yes.
It is only for the purpose of the stamp duty, and that is also minimum. And my lord, here, what surprises me is they did not place the notification. Therefore, we obtained under RTI, and if my learned friend, my learned junior will place it, my lord, we got it through letter dated 31/7/2025, where the rates are given. And if your lordship
All
can
right.
kindly
What is
see-
your next point, Mr. Mishra?
No, my lord, this is one point. Then the next point is, if my lord remembers, on the last occasion, your lordship said he did not deliberately participated before the hearing in the reference court. But ex parte, an appeal will lie against ex parte under section 96(2) of the CPC that has come from my lords.
Yes.
But my lord, the Supreme Court has circumscribed the limitation of the grounds on which it can be urged. So therefore, I'm saying, my lord, there are 2-3 points. It'll take some time, at least. So today, my lord, your lordship has taken some time. I mean, if it is not convenient, your lordship may take it up some other day. Your lordship will just see this notification by the collector by which the price is fixed. Just one line, top. That will clarify all the matter, my lord. My learned junior will have to go, my lord.
By this time, you should have sensed, Mr. Mishra, that the court is in your favor.
My lord, I have sensed.
So why you want to?
I will not argue. I'll not argue. I'll not argue, my lord, because your lordship said to give in writing. So I'll follow your lordship's this thing. I'll place my small note. I'll give.
Give a short note. At best, I will reduce it by 25% or something and uphold the decree. That's
My
all.
lord, that one again, my lord, 25% if your lordship reduces. My lord, there are decisions, Calcutta Metropolitan Development Authority's case, my lord, of 2011. This amount was reduced because of the size of the plot of land. But there only, my lord, his lordship has said that if the lands are developed, even if it is large, then there will be no deduction. And that, well, this is a developed land. They have taken out, they have carved out the best portion for themselves, 3 acres.
All right.
And then there they have
File your notes,
constructed
sir.
the
Dr. Mazika is a fairest of fairest counsel. He also realizes where the strength is, where the little weakness is, and he cooperates with the court. Yes, please take down. Hearing concluded. CAV. Advocate on record for advocates on record for the parties are at liberty to file written submissions with the court master attached to this court. By when, Mr. Mishra?
by 19th, my lord. 19th and file. 15, 16,
8 days you.
and file. 18 also.
By 18th.
18.
By 18th.
Well,
Okay.
Deep.
Item number 2 to
Yes.
obliged, my lord.
It's 2 to 7 are all connected matters, my lords. This, that.
We have to, but this court has to devote some time now. When should we, when should I keep it?
Lords, I will be only adopting the submissions made by Learned Senior Counsel, Mr. Who had appeared for respondent number 1, my lords. Mr. Khurshid had addressed your lordships at length.
And Dr. Muzika on that point.
So on that, we have done some research, my lords. 2 judgments have come out. My lords, we were referring to Article 20. Also, my lords, Section 30 of the CRPC.
Yes.
There's there, my lords, now, and the leading authority in this is that Rajiv Gandhi assassination case, my lords, Nalini's case, where my lords have gotten into that entire aspect, my lords, and the principle has been laid down. While Article 20, my lords, was only providing protection against conviction, Section 30 of the CRPC, my lords, provides for, even in cases of acquittal, I cannot be taken up subsequently. So therefore, the only question would then, my lords, fall for your lordship's kind consideration, whether an order passed in exercise of powers under 482, whether it would be an order of discharge or an order of acquittal.
No, suppose it is found
My lords.
that the charge sheet does not disclose any offence on the face of it.
And my lords, quash it.
Yes, in criminal jurisprudence we have to discharge
My lords.
the accused.
I would then humbly submit, my lords, Section 30 will come into play.
No, but what about that article of the Constitution
Article 20, my lords.
which says that no person shall be prosecuted or
My lords, in this, what had happened, my lords, there is, my lords, this case of Tokcham Bira Singh that was decided by the Honorable Supreme Court, my lords, in 1965.
yes.
Now, there, my lords, their lordships had enunciated a principle that if an, my lords, trial leads to an acquittal,
No,
then-
that's all right. He cannot be tried again.
no, my lords, they say he can be. That's what fell for my lords under Article 20. Then, my lords, in Nalini's case, took the law forward, and my lords, a French principle was then, my lords, brought in. As a matter of fact, that's in paragraph 237. My lords, they say, while my lords, in so-and-so's case, if there is no punishment for the offence as a result of prosecution, Article 22 has no application. In Bira Singh's case, my lords. Then they say, while the clause embodies the principles of auto foi convict, Section 300 of Criminal Procedure then combines both auto foi convict and auto foi acquittal. That's where, my lords, Section 300 comes into play. Therefore, my lords, if it is a judicial proceeding, in a judicial proceeding, if my lords find that, my lords, there is no case made out and the proceedings, the charge sheet is quashed, then, my lords, Section 300 will come into play. Then I cannot be charged for the same thing again. I cannot be put to trial for the same thing again.
Even if it is discharged,
My lords.
a fresh charge sheet cannot be lodged.
My lords, my humble submission would be that. Because Article 22, my lords, would grant me protection only for, my lords, if I am convicted. I cannot be convicted for the same offence twice. 300, my lords, deals with trial. I can place Section 300 of the, my lords, CRPC. Your Article 20. If my lords have Section 300, my lords.
CRPC.
My lords. BNS is now this is. I'll place Article 20 as well, my lords, so for your lordships can kindly appreciate what I'm saying. My lords have Section 300.
of this Bharatiya Sanhita.
My lords, of this BNSS, it is section 337, my lords. This is 256. 337.
Yes.
Section 337, minutes. It says persons one convicted or acquitted not to be tried for the same offence. That's the distinction with Article 20 subsection 2. Because there Article 20 says, no person shall be prosecuted and punished for the same offence more than once. Where's the judgment? Where's Nalini? There's a book.
That is Sanhita, which section?
337, my lords. Section 337 of the BNSS.
But discharge is not acquittal.
Discharge is not acquittal, my lords.
And there is also provision in the CRPC for correction of any error in the charge sheet.
If at the stage of trial, my lords, if the court finds that the charge can be altered or modified, that power is very much.
But then if it is flawed foundationally, then perhaps no correction can be made.
Cannot be. If it, my lords, one of the parameters of Bhajanlal will then come into play, that if it is so, my lords, convoluted that any reasonable person, my lords, would not come to a reasonable explanation that this is a charge. In that event, my lords would exercise powers under 482. I'll place Bhajanlal as well, my lords.
When should we keep it, Mr. Paul?
Any date convenient, my lords. Next week. Any date next week, my lords.
These applications are heard in part today. List these applications for further consideration. On 29th August. You also get ready in this point?
We'll try to conclude on 29. We'll try to
conclude it on 29.
Because of so many signatures there, that how can you point a finger at one person?
And what is that in this fact?
Whether a departmental proceeding would be more appropriate than a criminal prosecution.
The difficulty against Minister, my lord.
Whoever may be, but then just because something happens, you just can't start shooting. All right.
Start from the top.
Because my only concern...
The rule of law will apply equally.
My only concern is there are 3 accused persons, my lord.
Maybe, but then...
So it's completely... If the charges are interfered with, my lord, all 3 of them will go scot-free.
So you, all right.
I'll argue on that line.